Now, we know from our preparation so far that whenever a patent is filed and a patent is granted, any improvement, improvisation, modification to an invention can be filed by way of a patent of addition. So we know that the Patent Act provides for filing patents of addition, which can be done for small improvements which are connected to it. Now, what is the level of improvement? Is the level of improvement so substantial that it qualifies for a separate invention? Then it will be a separate application itself. But if the improvement is marginal, which can be connected to the, or it is linked to the inventive concept, then you take a choice of filing a patent of addition. So we know that if they don't talk about a grant, they rather talk about provisionals filed, and there is a time for, they say that you have now to file a complete. In that case, all the improvements can be clubbed together. Some of the improvements, if they were disclosed in a series of provisionals, you could file a common complete. Or if provisional shows the first part and there is an improvement made, you can include the improvement into the complete and file it as well. So if it was in the application stage, you would say that you can file provisionals and follow it up with a complete. Because now it's the grant stage, the patent has already been granted. The only way you can include a new thing is by way of patent of addition and not amendment. Okay, amendment is not the way forward, because Section 59 tells us constantly, it reminds us that you cannot broaden the scope of an invention. You can only narrow it down through an amendment. So the scope of the amendment is not to broaden, but to narrow down. So when we know that, we will understand that amendment is not the way to expand the scope of an invention. Rather, the scope of an invention can be expanded by filing a patent of addition.